So what is the power of attorney? Why do I need a power of attorney? There are many different types of powers of attorney. There are sort of two general categories. One is a power of attorney for property or for financial business decisions. Another category of a power of attorney is one for health care or mental health decisions. And so a power of attorney is simply a document where you say, I appoint this person to act on my behalf under these circumstances. So let's talk first about the financial power of attorney. A power of attorney can be a limited power of attorney or a general power of attorney. A limited power of attorney might be I give this person my authority to sell my car for me. Or I give this person my authority to sign the documents to buy this house for me. And so you execute a specific limited power of attorney for a specific purpose or for a specific time. A general power of attorney would be more general. Say, I'm appointing this person to make decisions for me in all of my financial affairs. These types of powers of attorney can be presently effective, meaning it's effective immediately when you sign it, or what we sometimes call a springing power of attorney that comes into effect on the occurrence of some future event or at some future time. A common future event for a springing power of attorney would be one that comes into effect once I become incapacitated. So if the decision is made, however I determine that decision would be made by my physicians or a disability panel or even possibly a court, I guess, although we would try to avoid the need for that. But once I'm determined to be incapacitated, then my agent has the authority to be able to act on my behalf to make financial decisions. So that would be a springing power of attorney. You also want to think about whether you want your power of attorney to be a durable power. Many limited powers of attorney would not be durable. Durable simply means that it continues in effect even after you become incapacitated. If you don't make your power of attorney a durable power of attorney and you later become incapacitated, then the power of attorney is no good. So if you want the power of attorney to continue beyond your incapacity, if that were to happen, you need to make sure it's a durable power of attorney. If you want it to be effective immediately and then continue even if you're incapacitated, then it's an immediately effective, durable power of attorney. If you want it to only become effective if you become incapacitated, then it would be a springing, durable power of attorney. It becomes effective upon your incapacity and it continues in effect while you're incapacitated. Now, one misconception about powers of attorney is many people believe if it's a durable power of attorney, then the person can continue to handle my assets after my lifetime. And that's not true. With all powers of attorney, when the person who created the power dies, the power of attorney dies. And so the disposition of property after your lifetime must be done through a will or through a trust or through some other type of arrangement of rights of survivorship or beneficiary designation, not through a power of attorney. We have many people who come in and say, well, I've got the power of attorney, this person passed away, so I'll go ahead and handle the assets. And it doesn't work that way. They need to be either appointed under a will, they need to be a successor trustee, or they need to be named with a right of survivorship or as a beneficiary designation on the particular asset. So that's for powers of attorney for property. Now powers of attorney for health care and mental health powers of attorney. A health care power of attorney is always a springing power. As long as you're able to make your own medical decisions, you make your medical decisions. So it's only in the event you're incapacitated, you're not able to make a decision for yourself, would the agent under your health care power of attorney or mental health power of attorney be able to act. Now, you've heard me say health care power of attorney or mental health. Those are usually combined together, and it's just a matter of whether you want to include a mental health power in your health care power of attorney. It's important to make that decision on whether you want to do that, particularly if you want to give the agent the right to have you admitted to a level 1 psychiatric unit. Now that's not something that we like to think about, but if you want person to have that authority, you need to specifically initial and authorize that in your power of attorney. If you don't, and the need comes for you to be admitted to such a unit, there would have to be a court proceeding and a court order for you to be admitted to that level 1 psychiatric unit. That could be avoided with a mental health power of attorney, where you authorize the agent to have you admitted to that type of a facility. And a level 1 psychiatric facility is a type of facility where you could be restrained. And so the concern is, if you could be restrained and your freedoms could be taken away, unless you've specifically authorized the person in your healthcare power of attorney or your healthcare power with a mental health provision to make that decision, then they don't have that power, and there's going to have to be a separate court proceeding before that can take place. So that's something that you want to think about with your healthcare powers of attorney. Again, this is an area where the laws have, there have been some recent changes. You may want to take a look at your powers of attorney. And the thing with powers of attorney, especially with the ones for property, they're really only as good as the people are willing to accept them. So if your agent goes into a financial institution and that financial institution refuses to accept the power of attorney, they don't have a lot of recourse. There's some other things you can do to help that. But as a general rule, the fresher your power of attorney is, the more likely it is that it will be accepted for what you would like it to be accepted for. So every year or so, when you take a look at your estate plan and you update your estate plan, probably a good idea to update your power of attorney. Again, if it's durable and you're incapacitated, you obviously can't do that, and that's fine. Once it's durable, it's good forever, for the rest of your lifetime. But if it's been several years since you've taken a look at your power of attorney, good idea to sit down with your legal counsel and other advisors and review that.